In this lecture, we are going to be covering the content from Chapter 7 of Electronic Commerce by Gary P. Schneider, and that's going to be covering legal, ethical, and tax issues in electronic commerce. So let's begin with our learning objectives for this module. Those learning objectives are going to be 1. Recall elements of an online business contract. 2. Explain when copyright, patent, and trademark laws govern the use of intellectual property online. 3. Explain how the internet has created opportunities for online crime, terrorism, and warfare. 4. Explore the conflict between customer privacy rights and a company's desire to collect and use customers' data. 5. Identify how taxes are levied on e-commerce activities. Let's begin with the legal environment. So all businesses must comply with the same laws and regulations and face the same penalties. Web businesses face additional complicating factors. So the web extends businesses beyond the reach of traditional boundaries. They're subject to more laws and more quickly than brick and mortar businesses. More interactive and complex customer relationships are a factor. Also, online communications facilitate strategic alliances and supply web relationships. And law violations or ethical breaches can lead to rapid and intense reactions almost instantly online. So a question we have to ask ourselves in e-commerce often is who's in charge here? So we need to know where the borders and jurisdiction are. And so in traditional commerce, some borders are very clearly marked. We have state lines, we have county borders, we have continents divided by huge bodies of water. But what happens when geography is no longer a limit? So we need to look at the relationship between geographic and legal boundaries, and we're going to look at those by looking at 4 variables, and that's going to be power, effects, legitimacy, and notice. And we're about to take a closer look at those, but we also need to keep in mind that culture impacts laws and ethical standards. Also, laws and ethical standards impact each other, but they're not the same thing. And so we need to keep all of that in mind. And something to remember is that just because something is right or wrong doesn't mean it's a law. And also, businesses have to consider the customer relationships that they're creating if they are only following the laws and not also ethical standards. So let's look at those 4 variables now. The first one is power. Power is the form of control over physical space and people and objects that reside in that space. So it's a defining characteristic of statehood. Jurisdiction is government's ability to exercise power. It's limited to that which is accepted by the geographical culture. 2 is effects. Effects are the impact of a person's behavior. Generally stronger on things that are physically closer. Laws based on traditional effect-based measures do not work as well in online businesses. 3, legitimacy. Legitimacy is the idea that those subject to the laws should have some role in formulating them. Online businesses face a variety of regulations. 4, notice is the expression of a change in rules. Easy for physical boundaries, but not as easy online. Constructive notice of new laws and norms is received when an international border is crossed. Ignorance of law is this idea of, I didn't know, so it doesn't count. But that's actually not a sustainable defense. One must make themselves familiar with the law. Also, notice creates problems for online business when unknown customers from other countries access the websites. So we have to make sure that our websites for our businesses are offering all of the information that the customer needs so that the customer can be following the rules. Due to the lack of geographical boundaries, jurisdiction on the internet is very difficult. Governments enforcing internet business conduct laws must establish jurisdiction over conduct. Contract is a promise between 2 or more entities provided for exchange of value between them. A breach in contract occurs if either party does not comply with the contract terms. Tort is an intentional negligent action taken by a legal entity that causes harm to another legal party. Sufficient jurisdiction requires both subject matter jurisdiction and personal jurisdiction. So subject matter jurisdiction is a court's authority to decide a particular dispute type. So U.S. federal courts have subject matter jurisdiction over issues governed by federal laws. U.S. state courts have subject matter jurisdiction over issues governed by state laws. So personal jurisdiction, though, is determined by the residents of the parties. If a defendant is a state resident where the court is located, the determination is straightforward. However, an out-of-state person or a corporation can voluntarily submit to a state court jurisdiction. Forum selection clause indicates a contract will be enforced according to a particular state's laws. Long-arm statutes create personal jurisdiction over non-residents committing tortious acts. Tortious acts are an exception to personal jurisdiction. When it comes to jurisdiction in international commerce, it's governed by treaties between the countries in dispute. U.S. determines personal jurisdiction for foreigners in the same manner as domestic long-arm statutes. Non-U.S. entities can be sued in U.S. courts. Foreign courts can enforce U.S. court system decisions against U.S. corporations and individuals. Judicial comity is enforcing other countries' laws out of a sense of friendly civility. There's also conflict of laws. We run into this in a regular sense of brick and mortar businesses, but for our e-commerce businesses, we're going to be seeing this quite a bit, this conflict of laws, because, again, of those geographic boundaries being so blurred. So businesses are governed by various federal, state, and local laws. Conflict of laws occurs when the laws address the same issue but in a different way. So if a federal law and a state law don't match up, or if you are conducting business through multiple states and those laws don't match up. Online businesses span so many localities that we usually look to the federal laws for guidance. This can also lead to problems with the state laws, though. Now that we've discussed some of the broader legal issues in e-commerce, let's also look at contracting and contract enforcement in electronic commerce. So a contract is formed when one party accepts the offer of another party. An offer is a commitment with certain terms made to another party that can be revoked. Acceptance is the expression of willingness to take the offer, including all the stated terms. Consideration is the agreed upon exchange of something of valuable, such as money, property, or future services. The implied contract can be formed when parties act as if a contract exists, even if it's unwritten. Now, when we think of contract, we need to make sure that we think bigger than just a written piece of paper. So every type of agreement or exchange between parties is a type of contract. For example, even a consumer buying an item at a supermarket is a contract, although there's not a written document that we're signing. Online, mostly we're going to be seeing contract acceptances through click wrap or web wrap. End user license agreements, EULAs, our users must accept the contract before installing the software, which may happen when you click agree. Oftentimes people don't read the end user license agreement. However, we click agree and therefore we are agreeing to whatever is in that licensing agreement. Click wrap acceptance happens by clicking a button on the website. Web wrap acceptance or browser wrap acceptance occurs simply by using the website. Terms of service agreements. Many sites have stated rules visitors must follow, even though the visitors are not aware of them. So terms of service agreements are detailed rules and regulations. They limit the website's owner's liability for what one might do with site information. Site visitors are held to terms of service simply by using the site. As businesses, we need to make sure that we have our terms of service available on our websites. When it comes to creating written contracts on the web, many contracts are valid even if not written or signed. We also have implied warranties and warranty disclaimers on the web. And as businesses, it's very important that we make sure that we have these available for our customers. Implied warranty is a promise to which the seller can be held even though the seller did not make an explicit statement of that promise. Law establishes basic elements of a transaction in any contract to sell goods or services. Now, if I'm selling a product online, it is implied that that product is going to work. And so if I sell an item online as a business, we need to make sure that our products worked. It's implied that they do work. Even if we don't give a 1-year warranty, a 2-year warranty, even if we don't offer those services, there's an implied warranty that it's going to work when it arrives. A warranty disclaimer is a statement declaring that the seller will not honor some or all implied warranties, and these must be made obvious and be in writing on the website. It's only legally effective if it's obvious and easy for the web buyer to find, because, like I said, it is implied that the item I'm selling works. So, who has the authority to form contracts? So, a contract is formed when the offer is accepted for consideration. Problems with acceptance by an impostor or forgery, or someone without the authority to bind the company. Electronic commerce technology provides means to avoid deception, such as use of digital signatures. Authority to bind issues arise when employee accepts a contract and company later asserts employee was not authorized. In electronic commerce, there's not always a physical product being sold. So we also need to be looking at the use and protection of intellectual property in online business. So intellectual property includes all products of the human mind, both tangible and intangible, protections afforded by copyrights, patents, trademarks, registration, service marks. The right of publicity is the limited right to control others' commercial use of an individual's name, image, likeness, and identifying aspects of their identity. Online businesses must avoid infringement of intellectual property rights by using unauthorized content on the websites or in domain names. Copyright is a right guaranteed by government to the author or creator of literary or artistic work. It gives the author or the creator sole and exclusive rights to the work, printing, publishing, selling for a specific length of time. U.S. law no longer requires registration. Work created after 1989 is copyrighted automatically by the virtue of copyright law. Fair use of a copyrighted work is an exemption from infringement. This allows copying it for use in criticism, comment, news reporting, teaching, scholarship, and research. So the way to think about this of when that is fair use of copyrighted work is when you are specifying that that is not your work. There are specific factors in fair use, and so nonprofit educational uses have a better chance of qualifying than commercial uses. For example, if I was to copy some pages from the textbook that I wanted you guys to look over for a case study, that would still be okay. I'm not presenting that work as my own, and I'm not distributing it in a way that would keep the author from making money. So outside of education, there are other times where fair use will still come into play. However, in most cases, it's best to not be using someone else's. And when it comes to a company using another company's information to make a profit, that's when major copyright laws are being infringed. Copyright law is difficult to apply due to the elements, especially just the nature of the internet and how the internet works. Vicarious copyright infringement occurs when an entity capable of supervising infringing activities obtains a financial benefit from it. So, for example, a long time ago when Napster existed and people were sharing music online, Napster was held liable for failing to monitor its networks and indirect profit from the infringement. Music purchased in digital form is often sold with specific restrictions on copyright and sharing, even for personal use. So that's enough about copyrights. Let's talk about patents. So a patent is an exclusive right guaranteed by the government to an individual to make, use, and sell an invention. Protection is for 20 years in the United States, or an inventor can patent the design for 14 years. Invention must be genuine, novel, and useful. Software patents are not considered useful because technology is obsolete before the patent protection is secured. The process is expensive and takes several years. Business process patent protects specific sets of procedures for conducting a particular business activity. It's only common in the United States. There's also trademark issues. So a trademark is a distinctive mark, device, motto, or implement that a company affixes to a good it produces for identification purposes. Service mark identifies the services provided. They're registered with the government. It's state, and or federal. Trade name is the name a business uses for identity. It's protected under common law, not trademark law. Statutory law arises when elected legislative bodies pass laws or statutes. Website designers must not use any trademarked name, logo, or other mark without permission. Domain names and intellectual property issues include cyber squatting, which is registering a trademarked domain name, hoping an owner will pay money to acquire that URL. Name changing or typo squatting occurs when someone purposely registers misspelled variations of a well-known domain name. Name stealing is unauthorized changes to domain name ownership. The domain name ownership change occurs when information maintained by a public domain registrar is changed in the registrar's database. This allows the name stealer to manipulate the site. It occurs when safeguards are not in place. The main purpose is to harass the site owner. So how do we protect intellectual property online? A digital watermark is a digital code or stream embedded undetectably in the digital image or audio file. It can be encrypted to protect the contents. Copy control is an electronic mechanism limiting the number of copies. So some deceptive trade practices include manipulation of trademarked objects, which is infringement of the trademark holder's rights. Fictional characters can be trademarked. Websites with links to other sites must not imply a relationship with companies sponsoring other sites unless the sponsorship actually exists. Trademark protection prevents buyer confusion regarding trademark holders' products or services. Trademark dilution is the reduction of distinctive trademark quality by alternative uses. Defamation in electronic commerce is also important to note. Defamatory statement is a false statement and it injures the reputation of another person or company. This can happen when the statement injures the products or the service of reputation. Websites must consider specific laws before making negative, evaluative statements about products. Designers must avoid potential defamation liability by not altering photos or images. Exceptions in the U.S. for defamatory statements about public figures, not in other countries. Per se defamation occurs when statements are so negative that injury is assumed. If a competitor makes false statements about another company's product on its website, that can injure the reputation of that company, and that is defamation. And so we see this sometimes with products, like we'll see a review site that will look over several products. However, if it's only a competitor making negative, untrue statements about another product or service from another company, that can be taken to court. Let's talk about advertising regulation. So the Federal Trade Commission, or FTC, regulates advertising, publishes regulations, and investigates false advertising claims in the United States. Websites include links to advertising regulations. Advertising claims that mislead sustainable number of consumers and material are illegal in the U.S. The FTC accepts referred investigations from organizations like the Better Business Bureau. The FTC policies include information on what is permitted in advertising. Other agencies that regulate online advertising are the Food and Drug Administration, FDA, the Bureau of Alcohol, Tobacco, and Firearms, BATF, and the Department of Transportation, DOT. So we've covered a lot as far as the legal aspects, and now we really need to look at online crime. So web crimes are online versions of physical world crimes and new online crimes. So theft, stalking, pornography distribution, and gambling, those were all things that already existed before the internet, but now they can be done in different ways using online distribution. So commandeering computer to attack other computers is a new crime that didn't previously exist, And so online crime has lots of different areas. Law enforcement jurisdiction obstacles. So prosecuting across international boundaries is very difficult. So there are new types of crime online. Every time that humans have new tools, they have new ways to help and new ways to hurt. So it's difficult to apply pre-internet laws to criminal actions on the internet. Most stalker laws are triggered by physical action, which are not effective against online stalkers. Cyberbullying is using technology to harass, humiliate, threaten, and embarrass others. We see this a lot with teenagers. We see this, and this can also happen with all the way up to celebrities or public officials. But we see teenagers and preteens facing cyberbullying quite a bit now. Laws have lagged behind technology, but states are starting to pass laws that address online offenses. Another online crime is infiltrating competitor computer systems with intent of stealing data, creating operational disruptions. National Retail Federation partnered with eBay and FBI to combat stolen items from being sold online. The internet can help law enforcement track criminals. Online warfare and terrorism, so going beyond just consumer thievery or things that affect just one individual at a time. We're in a new age of terrorism and warfare using the internet. There's a considerable number of websites that are operated by hate groups and terrorist organizations. We've seen just recently people are calling for social media to stop allowing hate groups on their platforms. And some platforms are trying to shut down the hate groups that are using social networking to spread their beliefs or their ideas, or in general to cause harm to others. There are instructions for creating biological weapons online. There are terrorist groups that recruit new members online. There's thousands of downloadable terrorist training films. There's a lot of content online that, while some of us say we need to get this shut down right away, it's very difficult to have the right jurisdiction and to be able to shut things down as fast as they're popping up. And that creates a very difficult task that didn't exist before the internet. While hate groups did exist and while terrorism did exist, it wasn't, they had different ways of trying to counter that as opposed to trying to do that online. The U.S. Department of Homeland Security and Interpol are devoting considerable resources to monitoring online terrorist activities and coordinating anti-terrorism efforts. So we have the internet being used for selling goods and services. We have it being used for some of, for crime. And then a lot of questions come up about what can be done to fight that, what we can and can't do. Also, ethical issues come up. So websites conducting electronic commerce should adhere to the same ethical standards as other businesses follow. Failure to do so will result in damaged reputation, long-term loss of trust, and loss of business. Web advertising or promotion should include only true statements and omit misleading information. Product comparisons should be supported by verified information. Organizations face ethical issues when collecting email addresses from site visitors as well. So in the U.S., no legal obligation to limit the use of information collected on websites. They may use the information for any purposes, including selling your information. As a business, you have to figure out the best way to respect the privacy of your customers so you can build that relationship with them. But there's still information that you want to gather from your customers, so you still want to have those information forms they fill out. You still want to be getting their email address so that you can email them, so that you can be keeping them in constant contact with your product or service. So that brings us to privacy rights and obligations. We've seen in the recent years that privacy rights a lot has happened with privacy rights. In recent years, we receive statements, sometimes written statements in the mail, or when you go to a website, sometimes you'll see the privacy rights right away. And that is because they have to. And so They have to make sure you're aware of what your rights to privacy are. So let's look at some of those privacy rights. The Electronic Communications Privacy Act of 1986 was written pre-internet, or pre what we know as the internet, to deal with telephone lines. We haven't had any major laws enacted to address online privacy in the ways that we need it to, and one of those reasons is because the nature of the internet means that everything is constantly changing. The process of creating laws is a slow process, and so we can't always get what we need today isn't what we need next year or 2 years or 5 years. And so the issues change, which makes it very difficult to get the laws up to date. Direct Marketing Association established a set of privacy standards for members. There's significant ethics issues in online privacy, and my suggestion for you as business people, as future business people, possibly business owners or managers, is to always err on the side of creating good relationships with your customers. And so remember that what is right isn't always what's law. And so you don't want to break any laws, but you can't just say, well, there's not a law saying that I can't do that. I mean, you can say that and you'll be legally correct, but you won't be customer relationshiply correct. And so privacy advocates urge the use of electronic commerce sites to be conservative and follow these guidelines. Data collected for improved customer service or other customer benefits. Do not provide customer data to others outside your company without your customer's permission. Clearly describe and explain what data is collected and how it is used. Give customers the right to have their data deleted, and train employees on how to keep data secure. About giving customers the right to have their data deleted or clearly describing and explaining how it's collected. Oftentimes customers are not going to read through that information, but having it available there is part of what's important and part of creating a great relationship. There's some controversy in the U.S. about whether opt-in or opt-out is the way to do it. Opt-out is a common method where customers must deny the permission and opt out of having their information used. The other, which is less common, is where the customer must give permission for that information to be used. Another area of privacy rights involves communications with children. So there are additional considerations that arise when the websites attract and communicate with children. Children are considered less capable of evaluating information and sharing and transaction risks. Concerns arise about their ability to read and evaluate privacy statements and to consent to providing personal information. In most countries, people under 18 or 21 are not considered adults. Specific laws for children's privacy rights define a child as a person below the age of 12 or 13. There's the Children's Online Privacy Act of 1998. In 2001, there was the Children's Internet Protection Act, in which federally funded schools installing filtering software. Companies with websites appealing to children must be careful to comply with these laws. In 2013, FTC rules had some clarification. You must post clear and comprehensive online privacy policy, notice to parents, and verifiable parental consent. Give parents choices of allowing data collection without disclosure to third parties. Provide parents access to their children's information. Have option to have it deleted. Give parents opportunities to prevent further data collection. So I know this lecture has covered a lot so far, but we still need to talk about taxation. So web businesses must comply with multiple tax laws. There are several types of taxes. There are income taxes levied on net income. There are transaction taxes, transfer taxes levied on products or services that a company sells or uses. That's like sales tax, use tax, excise tax. And there's property taxes levied on personal property and real estate. Nexus is the connection between tax-paying entity and government. It's similar to the concept of personal jurisdiction. Activities creating nexus in the United States are determined by state laws that vary from state to state. Frequent litigation has resulted in fairly complex laws. Determining nexus is difficult if the company conducts few activities in the state. Business conducted in more than one country may establish nexus with a country and be liable for filing tax returns in that country. U.S. income tax. So the IRS is charged with administering tax laws. Any verifiable increase in a company's wealth is subject to federal taxation. A company must pay federal income tax if it has a U.S.-based website generating income. Website is maintained by U.S. company, and therefore it must pay taxes on income generated outside of the United States. Credits given for taxes paid to foreign countries to reduce double taxation of foreign earnings. Most states also levy income taxes on businesses. U.S. state sales tax. Transaction tax on goods sold to consumers is usually called sales tax. Businesses establishing nexus with a state must file sales tax returns and remit sales tax collected from customers. Business is not required to collect taxes from out-of-state customers unless the nexus is established. Use tax is a tax levied by a state on property used in that state that was not purchased in that state. Large companies use complex software to manage their tax obligations. We also have import tariffs. So countries regulate import and export of goods. Sometimes goods can only be imported if a tariff is paid. A tariff is customs or duty is a tax levied on products as they enter the country. There are many reasons for imposing tariffs. Goods ordered online are subject to tariffs when crossing international borders. Products delivered online are also subject to tariffs. An example would be downloading software from another country. Now, that's a lot to take in. That's a lot about taxes. We aren't going to focus too heavily on taxes, but you will be expected in this course to understand some of the basics about how taxes are levied. And also, you should be able to, by the end of this chapter, you should be able to understand, privacy rights and understand that conflict. As a business, you want to get all the information so that you can sell more items, so that you can provide the right goods and services to your customers, so that you can expand and build that customer relationship. But you don't want to harm your customer relationship by collecting too much data and selling it to other parties or putting their data at risk. So we just have to keep in mind that the internet creates a whole new set of issues. So all of the issues that you already know exist in business, you need to go ahead and also consider the way that changes when you're working with electronic commerce. And from the business side, what you need to do to avoid online crime, to avoid copyright infringement or any type of intellectual property infringement. And then lastly, in this chapter, you also have learned about business contracts and should know the basic elements of that, and that a contract is not always a written agreement. If you have any questions about this chapter, please let me know. I'm always available to clarify. I know that this chapter had a lot of content, so if you need clarification, just let me know.